Good afternoon, everyone. It's an absolute pleasure to see you all at our fourth ICCA Bar Course webinar. My name's Chris Kesseling. I'm Vice Dean of the Intercourt College of Advocacy, and it is my pleasure to introduce two of my colleagues today. First of all, Michelle Fawcett, who you can see. Michelle's in the top left-hand side of my screen, but I know what Zoom's like. She might be anywhere on your screen.
Possible.
Michelle is the lead criminal tutor at the ICCA, and you'll be hearing from Michelle all about what we call criminal advocacy, but we'll give you a far clearer explanation of exactly what that is. Secondly, it's also my pleasure to introduce Alex Frith, who is the joint lead civil tutor at the ICCA, who will be, I hope, because I need this as well, giving us some clarity to exactly what civil advocacy is, which we also call submissions advocacy. The whole idea of today is that we want to really make it clear as possible to you what advocacy on a bar course is. Of course, we'll be focusing on the ICCA bar course, but really this is of general application because lots of what we're talking about will be applicable on any bar course that you choose to go on. And so not only what you can expect to do on a bar course, but also we hope to give you some hints and tips, some do's and don'ts that will really enhance your advocacy ability as you move forward, not just in terms of things you might be doing right now, such as mooting or general public speaking, debating, for example, but also when you get onto the bar course to give you a head start in terms of certainly what we're looking for and how, of course, to get the best marks, which is always very helpful in any assessment you're doing in advocacy, but also, of course, a number of chambers, when you're applying for pupillage, will want to do an advocacy exercise with you. Relevant, of course, to the type of work that they do, which is why we're covering the whole gamut of advocacy today, from the criminal side all the way through to the civil side, and what would also be included, for example, if you wanted to go into family law. So all of these things are of general application to you. So I want to start off by passing over, first of all, we're going to go into a lot more detail here as we move on. Oh, I should say, actually, before I start, if you want to ask questions, please use the Q&A rather than the chat function that you can see at the bottom of your screens. I will be monitoring that as we go through, and I will find convenient moments to ask Michelle and Alex any questions that you may have. So please feel free to use that. But first of all, we at the ICCA break advocacy down into two parts, essentially, what we call criminal advocacy and what we call civil advocacy. We'll get into the detail of what they are in a moment. But as a general overview, Michelle, what is criminal advocacy?
Well, certainly at the ICCA, that takes part over three different subjects. So we have conference skills, which is where the students will be role-playing as counsel and holding a conference with a lay client. And then we have the actual witness handling, as we tend to call it colloquially, and that involves examination in chief, which on the course at the moment means taking a defendant through their evidence if they were giving evidence during the course of a trial. And we also have cross-examination, whereby the students role-play counsel as if we were in a trial setting, and they are asked to cross-examine one of the witnesses who has already given evidence in the case. So three different modules as far as the criminal advocacy is concerned.
That's really helpful. Thanks. As a general overview. And Alex, what do we mean by civil advocacy?
Well, civil advocacy, the final assessment is a submission to a judge in usually some form of application. But throughout the course, we do some work on that. So lots of applications where you've got an opponent, where you haven't got an opponent, largely being asked questions by a judge in very realistic situations. We will also do some witness handling within the civil course, of course, because there are some slight differences between what will happen when you're dealing with witnesses in a civil case. For example, in civil cases, the evidence in chief is usually given by the form of a witness statement. So that is slightly different, although there's a lot of overlap with the skills with that. But the focus for civil advocacy is going to be on very realistic, what would actually happen when you get into court and you're talking to a judge.
And I guess for a lot of people out there who are doing mooting, civil advocacy would be more similar, certainly, to criminal advocacy, because there's no real witness handling involved in mooting.
Yeah. I do tend to find that mooting is slightly more abstract and slightly different. So we're very much about the practicalities. What happens when you get to court, how to talk to the judge, and what might possibly go wrong and how to fix it.
Okay, which we will look at in a moment. Before we get into the practical aspects of advocacy, both criminal and civil, I'd like your thoughts, if possible, about what an awful lot of barristers, both of you, of course, as myself, experienced barristers, and I certainly have my views on that. But let's just focus for a moment on preparation, because I think most practitioners would say that essentially 90% of what amounts to good advocacy occurs before you go into the courtroom. That actually good preparation is crucial. Can we focus on you for a moment, Michelle, in terms of criminal advocacy, particularly examination in chief and cross-examination, but conference skills too? How much work would you have to expect to do, and why?
Well, certainly, I mean, different levels in terms of if we're talking about going off to court and doing a trial, but if we're focusing on coming onto the course, certainly we do put within the student instructions that a minimum of 5 hours preparation as far as the subjects are concerned will be needed by the students. The strongest thing is absolutely revolving around preparation and actually understanding what the case is. And one habit that we tend to find, because I'm sure we've all been there when we're at university, is getting the brief, getting the papers, and immediately having either a highlighter in our hands if we have a paper version, or ready to cut and paste on an electronic version. And the issue with that is you don't really know at that stage what it is that you're highlighting or cutting or pasting, because you don't know the case well enough. And so certainly at the ICCA, we advise everyone that when the papers come in, whether that be in paper or on digital format, you should be reading your case papers at least 3 times before you even attempt to dissect what's in issue in the case and understand where any potential trial issues are going to arise or the type of questions that you need to ask. And that tends to have been a very successful tool in terms of us saying to the students, just keep repeating the facts, because later on, certainly in criminal trials, you need to know the case inside out. You need to have the facts literally at your fingertips to be able to make an immediate decision as to that's not what you said earlier, that's not what's in the witness statement, and certainly for cross-examination, that's not what you just told the court in examination in chief. So the situation with criminal advocacy is it's extremely fast moving, and you have to be ready to be flexible and to adapt at any given time. And the key to that is absolutely knowing and understanding your case, which comes from good preparation. If you don't take the time to actually absorb that in the beginning, Chris, there tends to be a tendency to not appreciate what's actually an issue in the case. And therefore, time can be wasted subsequently in talking about irrelevant matters or matters that are actually agreed. And that takes the focus away from what it is that people have actually got to decide upon. And so the preparation also assists with that side of it, limiting the issues and therefore hopefully keeping the advocacy and indeed the length of the advocacy to the minimum.
Before I move to you, Alex, let me ask you a difficult question, Michelle, because certainly a number of students ask me this. They go and do particularly a criminal mini pupillage, and they go into court and they see a criminal barrister, either for the defence or the prosecution, but particularly for the prosecution, given a brief at the last minute that they literally receive there and then in court. And then within 2 minutes, they're opening that case to a judge beautifully, mellifluously, as if they know that case so well. How on earth does that happen?
It happens far more frequently than we expect, Chris, to be honest. But the reality is an awful lot comes with experience and with practice and with being confident in your advocacy in the first place. The thing to remember as well is most judges are actually approachable if you needed extra time to be able to just get the thoughts clear. Most of them would grant it, understanding the situation you're in. But you're right, certainly at the start of practice, an awful lot of pupils are going out to court, for example, with no information at all. They literally have, which when you and I started, just a back sheet, it was a piece of paper with someone's name. We knew nothing about it until we actually got to court. And even on that basis, it's important with one document as simple as the case summary itself. Just absorb that one document and understand what the charge is, what the nature of the offence is, and very specifically what it is that the person is said to have done, rather than just focusing, on an awful lot of waffle that may not potentially be relevant. So it does attract speed reading. It does attract having to be fast thinking and forward thinking. We're always at the criminal bar doing 2 or 3 things at once. We are listening to what's occurring. We are potentially reading anything to see if it's different. We are forward thinking with what the next question or the next submission, because we make submissions in criminal advocacy as well. I always say to students, there's about 10 trains going through my head at any given time. And the ideal is being able to work out which platform you're on and which you're going to jump onto at any given moment. I'm ready to realize, hang on, I'm on the wrong train. I need to move now. So it's a combination of factors where criminal advocacy is concerned. And I always tend to think it's a lot more fast-paced potentially than civil, where you have the submissions, you can slow it down. The problem with criminal advocacy, of course, is you never know what someone's going to say in court until they say it.
Yeah, that's really helpful. So let's move to civil advocacy, Alex. I mean, I've always been slightly jealous of civil barristers, and I might be wrong about this, but it seems to me that you generally know what you're doing next week, unlike criminal barristers, where you rarely know what you're doing next week. Is there any truth in that? And how do you go about preparing for cases?
Not quite so much. I mean, a lot of the sessions that we do on the course, I've started off by telling students, what's your plan A? What's your plan B? And what's your plan C? Because plan A will be if everything goes according to plan and you end up doing a trial. Plan B will be if somebody doesn't turn up or something hasn't been served, what do you do then? And plan C might well be, what do you do if the judge just says, I'm going to adjourn this? So you do need to be quite fleet of foot in terms of thinking about what is actually going to happen. And I find that the most challenging thing, and the thing that we do much more to teach than anything else, is when you're going to court, don't expect to have all of the papers there. Don't expect there to be an answer. Certainly don't expect, like with mooting, there to be 3 cases that you've got to convince the judge to find for you on those. That hardly ever happens. What you do need to do is be very, very aware of what your client wants, what the court can actually do for your client, and how you might help the court to come to the decision that it can make with the facts and with the papers. So all of the procedural stuff that they study, the students will study on part 1, it doesn't go away. It's there all the time. Yes, you can look it up as you're going, but you really don't want to be looking everything up. So a lot of advanced planning of all the various things that might happen and might not happen. So while you can prepare quite a lot, and you'll do a lot of background research into law and procedure, but it really often just stays in the background. It's for you to know that you know what you're doing, but it's a very practical skill.
Yeah, that's really helpful.
Cases.
So, I mean, it's one thing that certainly we do for everyone watching. We really try at the ICCA not just to prepare you for passing exams, but to prepare you for practice. And what Alex has just said, I think, is a really good example of that, because it can be a real shock when you start in practice that things aren't exactly as you anticipated, and you have to be flexible and you have to think on your feet. There's absolutely no question about that. Okay, so let's move on to some practicalities. I'm going to focus for a moment, if it's okay with you, Michelle, on examination in chief, because in terms of the 2 modules we do for criminal advocacy, putting conference to one side for a moment, they are combined of what we generally call witness handling, examination in chief on the one hand, and cross-examination on the other. So what is examination in chief exactly? And what are the constituent parts, if you like, that enable someone to effectively examine a witness in chief?
So examination in chief, excuse me, Chris, examination in chief is where you would be what we call taking a witness through their evidence. In other words, you are the person that is assisting the witness, and it's no more than that, to give their evidence to the court, to give their version of events in terms of what happened and to explain their side of the story. Now, the important thing to remember with the examination in chief is that evidence must come in the witness's own words. It is not our role as counsel to say the story for them. And quite evidently, a judge will say during the course of summing up that the jury, if it's in a Crown Court, can only try the case based on evidence that is heard from the witness box, and that counsel can't give evidence, and that's a fundamental rule. And so therefore, as far as our students taking the role of counsel during examination in chief sessions on the course, we take time to make sure that they understand that the witness, and in fact on the course, we only have one occasion at the moment where it's a prosecution witness. The rest of the time, they're actually taking their own client through giving evidence in chief. And it's important to remember the defendant can be a witness, obviously, to his own case as well. But the emphasis is very much on remembering that it is down to counsel to assist, but it is also down to counsel to make sure that the full story is emerging. And always in our minds is, what is it that the witness needs to say to assist either the prosecution in proving the case or the defendant in showing what his defence is and why he says he's not guilty of an offence. So we have a prompt tool, if you like, in terms of making sure the witness is giving their account, but it's always with that in mind, that it has to be the witness's own version of events and their own evidence. So that's what we do as far as examination in chief is concerned. Get the witness to tell their story in their own words, making sure that they have provided the amount of detail that's required.
So that sounds beautifully simple. But the reality is, as we know, the examination in chief is, certainly in my experience, probably the subject in advocacy that students struggle with more than others. So why can't I just say, if I was going to ask you, for example, what had happened at this webinar, so Michelle, tell me what happened in this webinar up to this particular stage. What could there be anything simpler than that? What are the complications?
Well, the complications are what I think happened at this webinar and what you think happened may not be the same for starters. And in terms of the level of content and what it is that the audience actually need to hear, again, there are different views and versions as far as that's concerned. And the problem with just saying to someone, and this is exactly what we tell students not to do, can you tell me what happened, is that as counsel, you've lost control. You've immediately handed over everything to the client, and now you hope they are going to be able to relay the information that it is that you actually want them to say. And of course, that can be quite difficult, and it can, lack of control can cause massive issues. We also don't want to end up having to go over the story 2 or 3 times because the person we've asked to tell us their story hasn't given the very piece of information that we wanted them to give. So it's dangerous to just sit back and say, describe in your own words, Chris. It's always for us as counsel to ask the right questions of the witness to make sure that that piece of information or that part of the story comes out in sufficient detail that everyone understands and everyone has the same picture in their mind, if you like, of what it is said to have happened.
And the part which certainly I get a lot of questions about is that it has to be the evidence of the witness, not the evidence of the advocate. So if, for example, your case is that person A walked over the road and punched person B in the face, you can't say to the witness, so it's right that you were walking down the road and you walked across and then you punched person B in the face, didn't you? That's not examination in chief. That's more about cross-examination. It's leading. What is leading, and why is that to be involved and to be avoided rather? And how do you get round leading a witness?
There's several questions all rolled up there, Chris. You've just broke
Which
one
I'm
of
not
our
allowed to do, I know.
rolling up questions. 1 point per question in advocacy, please. The situation is, in fact, and it tends to be a common misbelief when people arrive on the course, because you can ask some leading questions in examination in chief. And this, in fact, relates back to that you asked us about earlier, preparation. If you have prepared your case and understood your case, quite often there is material that won't be an issue. And for example, it can be something as basic as, someone's name and how old they are, and if it's relevant, which school they attended, what they do for a job. an awful lot of background information is never going to be in contention, and so we can lead on that. But the important rules of evidence are that when we are actually dealing with matters that are in issue between the parties, so in this case between the prosecution and the defence, then the witness must deal with those issues in their own words. And it is for them to give the evidence, as you've said, not for counsel to try and put words into the witness's mouth. And so what happens is, as counsel, it is important that we almost put the brakes on when we come to that part of the evidence that's in dispute. And we very much then start to ask a series of short questions of a very closed and precise nature, so that the evidence is coming out in a controlled manner and counsel has the ability to appreciate very quickly that's the detail that we needed, rather than sitting back and hoping a witness is going to say the right words at the right time. But the difficulty, if you were to lead, given the example you said, is that immediately there's objection from the other side, because you are doing exactly that we're not supposed to be doing, giving evidence on behalf of the witness. And that obviously breaches the rules as far as criminal litigation is concerned. If that happens during the course of a trial, the number one factor is that a judge obviously will intervene and interrupt, and you're left looking incompetent in front of your jury or in front of magistrates, which is the last thing that we want to do when we're trying to be persuasive as far as our client's case is concerned. So it's about appreciating during the preparation stage the matters that are in dispute and the matters that aren't. And when you take the witness through their evidence in chief, small, precise, closed questions to make sure you're getting that level of detail about the very important facts that someone else has to decide.
Yeah, that's really helpful, because I mean, in most cases, certainly the location of an incident isn't in dispute.
Yes.
The time it occurred. So you could happily say, for example, if I was going to ask you a question, where were you on the 1st of November at around 12:30?
Yes.
Yeah, and that would be a good start. I mean, I remember being at some time ago at Derby Crown Court, where a lovely barrister called Alistair Monk was prosecuting, and he was told by his opponent, you can't lead on anything. So he was wondering what to say. First of all, opponents can't say that to you, but he took it a bit too seriously. So he just said to the witness, "Why are you here?" And the witness turned around to him and said, "Why are you here?" Which was which is pretty much where you get when it doesn't work out.
It's
As
there's a great example there. I had a student, in fact, in a class this week. We were talking about attending a wedding, and the question came out. We all knew what the question should have been, but the student asked, who was at the wedding? And something as wide open as that, could have led to a guest list of 500 people being read out, because technically the witness is answering the question. And it's a great demonstration of what he actually wanted to know was who was sitting on your table. It's that level of detail to make sure that the answer comes out far more precise and relevant to what it is that the tribunal actually need to hear, as opposed to that very overgenerous, I'm too scared to lead. I don't even want to say that you were sitting at a table, therefore I'll go as wide as who was at the wedding. It's a skill that comes obviously with experience and with practice, but we do find an awful lot of students take the approach that, first of all, we can't ask leading questions during examination in chief, and you absolutely can in the way that we've just described. And secondly, there's a very large misconception about what a leading question is. And I think that tends to be something that the focus, certainly coming onto the course, it needs to shift. For as I just said to you, who was sitting at your table? People say to me, that's a leading question. You are suggesting that they were sitting at the table. Technically, yes, but I'm sure it's not going to be an issue that someone was sitting at the table. There's so many different things involved in questioning technique quiz, which is what we're really talking about here. But at any given time, it is important that once we've moved past, using my example, who was sitting at the table, and we're going to talk about the incident, that's when you then must, of course, revert to non-leading and allow the witness to give the evidence in their own words.
Yeah, that's really helpful. And I think another thing that might be worth mentioning is that very often when you get a statement from a witness in a criminal case that's been taken down by the police, it's not necessarily in an order that's going to make an awful lot of sense to either
Yeah.
a jury or magistrates in the magistrates court. So that's another thing, isn't it, that students need to focus on, how they're going to actually structure their case so it makes as much sense as possible to a jury.
Well, there's also the other example, Chris, if someone makes more than one statement. There's
Yeah.
no point going through one complete statement and then coming back in and trying to interweave, interpose, or having the story said twice. And this is why certainly we teach students at a very early stage that during preparation, which again, we can't emphasize enough, a handy tool is to actually draw up your own timeline and to have the start to the end of the incident, and then to break down that timeline into relevant time factors, whether that be 5 minutes, 10 minutes, 30 minutes, depends on the length of the incident. But what you are very much able to do if you use a timeline situation is throughout the entirety of the case and every witness, you can put in on the timeline what their evidence is at any of those given moments. And you immediately have a very visual tool that you can use. And it gives you that prompt that when you are taking the witness through their evidence in chief, what time period are we talking about and what is it that they said happened? So timelines are a really important tool that certainly on the criminal advocacy side, we can't push highly enough.
The final thing, thanks, Michelle. The final thing I'd like to ask you about examination in chief is this. That there are some witnesses who, of course, it's like getting blood out of a stone. They don't really want to say much. They're scared about being in court. Other witnesses are delighted to be in court and they want to talk. They want to talk. They want to run away with the whole thing. And so essentially, if you say what happened at so-and-so time on so-and-so date, they want to take over the show and run away with it. How do you deal with a witness like that who just takes off? It's almost like you put batteries in, press play, and off they go. How do you slow someone like that down?
Politely and calmly is the way that we should deal with it. But you're right. We often get some witnesses who, once they've started to tell the story, don't want to stop. They're in their flow. The situation is normally with examination in chief, when we introduce a witness to the court and they are asked to give their name, etc., we would be reminding them at that stage that everyone in court is listening to the evidence and that certainly judges and counsel and potentially members of the jury are taking notes. And therefore, it is important that they take the evidence nice and slowly so that everyone can follow what's being said and have the opportunity to catch up if they're starting to get behind with their note taking. You and I know, Chris, from experience, there's nothing worse than a judge interrupting the witness and saying, whoa, stop, I'm not there, I've missed this part. This is why we call it witness handling, because it's all about you having control and appreciating the speed that the witness needs to give their evidence, and to make sure that if they are covering a very important point of evidence or a piece of information, stop, let's go over that in a bit more detail. And so what we tend to do is interrupt them politely but firmly. And I always say, own it. Make it look as though it's you as counsel that's got the problem. So I quite often interrupt by saying, I'm so sorry. I just need to go over that in a bit more detail. Or, Mr. Smith, what you're saying is extremely important. Let's just break this down a bit. Just draw their attention to the fact that they are going too fast. And it's about maintaining control, Chris, and making sure that the witness understands, just because they know the story, they were there, remember, that it's a memory for them. Other people in court weren't there and they have to hear this for the first time. So the pace that the evidence comes out is extremely important, and it is down to us as counsel to make sure that the witness understands that. Of course, we're always going to do that in open court. We don't have witness coaching at the Bar of England and Wales, and so anything that we say to the witness of that nature is done in front of the judge and jury so that they understand why we are saying what we say as far as the witness is concerned.
That's really helpful. Okay, so we've looked at the examination in chief, the approach you need to take with non-leading questions regarding those areas of evidence that are in dispute. Let's now move to cross-examination. First of all, Michelle, what's the fundamental purpose of cross-examination? What is an advocate essentially trying to achieve?
Well, there's not one purpose. I always explain this to students by saying, in fact, during cross-examination, as counsel, we have a dual purpose, as in DUAL, not as in diamonds. We are always running two different things at the same time during cross-examination. The first role as counsel is to undermine that witness's evidence. And so if we think about this procedurally, the witness we are about to cross-examine has just given their evidence in chief. They have explained their version of events to the tribunal of fact. They have given their story. And our role as counsel in cross-examination is to step forward and say, in effect, there's another side to this story, and maybe you can't rely upon this witness. And then we demonstrate it by undermining the credibility of the witness. Now, a great way to do this can be by introducing their character, if they have bad character. It can be by showing that actually their evidence to the court is inconsistent with that they said in their statement previously. And so a very heavy focus goes on undermining the credibility. But at the very same time, Chris, and this is where the skill comes, our role as counsel is to advance our own case. So whilst you are undermining that witness and showing that perhaps they're wrong about this piece of evidence or they're unreliable, you are also explaining to the jury what you say actually happened on behalf of your client, or in fact on behalf of the prosecution, so that they are understanding the compare and contrast, if you like. So cross-examination is actually extremely difficult. It's great fun if it's done properly, but we do, I'm afraid, see an awful lot of students tend to focus on one or the other. So there'll be a heavy, we must undermine, and we can fully attack this witness without realizing they're not actually explaining what their own case is. So that's certainly something we focus heavily on the course, making sure that the dual function is occurring. And hopefully by the time they leave us, they've got the skill to be able to do that.
So it's remembering that there's two parallel lines essentially.
Yes.
One is the undermining, and the other one is the advancing your own case.
Correct.
But it's right, certainly in my experience, and I anticipate yours as well, that very often when people do their examination in chief, as they should be, they are somewhat they're being helpful to the witness because it's their witness. But when they move into cross-examination mode, they become antagonistic and somewhat angry. Is that okay?
No. And in fact, one of the first phrases we teach students at the ICCA is cross-examination does not mean cross-examination. Quite often there are witnesses in actual fact that their evidence is helpful to our side. And so the shift then needs to be actually re-emphasizing and extracting that positive evidence. And that can come as quite a shock to a witness. I think the way we always describe it, Chris, is if you think about cross-examination from the witness's perspective, they have, as I've said, just given their version of events, and quite often they're very proud to have done so. And then you hear prosecution counsel say, if you'd like to wait there may be a few questions for you. And so that's the tip off to the witness that I'm about to be cross-examined. And visibly, you quite often see witnesses, they puff their chest. That's it. They're ready for the attack because they automatically assume I'm about to be attacked in cross-examination. And it comes as quite a shock when actually sometimes we're very nice to the witness and we're agreeing with an awful lot of their evidence. But the skill to address your question is very much no. Probably you're going to be aggressive in terms of the nature of the cross-examination rather than your actual tone and voice. One case in every 10. The actual art and skill in witness handling is to do the opposite, to remain calm and composed and to make your point effectively without getting involved in arguments with that witness that you're cross-examining.
Yeah, that's really helpful. And just to be clear to everyone that's watching this, even though we call cross-examination part of criminal advocacy, cross-examination occurs in multiple civil cases as well. I think I'm right, and you're going to put me right on this or tell me I'm wrong, Alex, but examination in chief rarely occurs in a civil case. And can you explain the reasons why?
Yeah, it doesn't. And actually, while you were talking, I think a lot of people, and you and Michelle may have been guilty of this, think, oh, examination in chief in civil, simple. You don't have to do it. And to an extent, great. But the disadvantage we do have is that our evidence in chief of our client, for example, is in a witness statement. And that witness statement wasn't written under our direction. It was written usually by the solicitors at some point previously. It may not have all of the information we want to get across in the right order. There may be some gaps. So that would mean that you have to make an application to the courts to ask additional questions, which you then do have to do, generally speaking, in a non-leading way, although you might do it with permission. What it also, I think, often means for, particularly for students, is they don't tend to know the story, the witness's evidence, as well as they should do. Because we read it and we skim through it and we look for certain things, but we don't necessarily pick up on that detail. So one of the skills for the advocate in civil is to really know what is in that statement, what extra things need to be in front of the court, so you don't get to the end and your judge says, well, your client didn't say that. There was no evidence on that. So it does need monitoring in exactly the same way that you need to analyse your case for examination in chief. It's slightly easier in that you know what you are going to get and what is already there, rather than hoping that the witness does actually say it on the day in court.
That's really helpful.
Sorry to cut across.
Sorry, Michelle.
But I think this may be helpful because it comes as quite a shock when students arrive on the course. Alex has given a beautiful description of examination in chief there and how it goes on the witness statement. And this is the problem. In criminal advocacy examination in chief, there is a misconception that everyone has the witness statement and that potentially 12 people sitting on a jury know what the witness said before.
Yeah.
And of course, that's the exact opposite. In criminal advocacy, nobody gets that witness statement except for counsel, the defendant, and the judge. And that is why it is so important to get the level of detail out in criminal advocacy, because you cannot assume everyone is understanding the case and following the evidence. And of course, they don't know what this witness said before because juries never, ever get those witness statements. And so if you think about having to come to factual decisions in civil advocacy, as Alex says, it will go on the witness statements and what's contained in writing. That is the direct opposite of examination in chief in criminal advocacy, where those witness statements are never seen. It is absolutely oral evidence coming from the witness under our guidance.
That's a really valuable point, and thanks for making it, Michelle. Okay, so we've looked at examination in chief, we've looked at cross-examination. So let's move, Alex, to submissions advocacy, what that really means, and what the if you like, that your top tips are for making that work as well as possible from a practical perspective.
Yeah. Some of the submissions advocacy we do, and certainly the way that students are assessed on the course, is very nice and straightforward. So you have a set of papers, you have an application you need to make, you get to sit down, think about it, draft a beautiful skeleton argument. So that is a summary of the arguments you're going to make, do your research, put your case law in, and then you stand in front of a judge and you make your submissions. That's a lovely theory. But what does tend to happen in real life, and we spend a lot of time on the course doing this, is that you do all of that and then you're faced with the judge, and the judge really, they've looked at it, they've got some questions, they've got things they want to know in an order they want to hear it in, and you have to deal with that, answer their questions and address their issues as they go through it. So we do make sure that we take students through that approach, which is the much more usual approach. Certainly if anybody goes to the county court, watches a district judge dealing with an application, it will be largely in the form of questions. Some judges, of course, know an awful lot more about procedure than others. So in preparing your civil advocacy, you do need to make sure that you understand the procedure. And I do find with students, so at this level, because we're all learning at the same time, they are, yes, good students will make sure they know all of the law and all of the procedure. But then there is a tendency to decide that what they now have to do is to spend their time giving the judge a lecture on what the law is and what the procedure is. I mean, for most judges, they will say, yes, yes, we know. the key thing is to understand that you need all of that, but you then need just to use that. It's a tool to allow you to present the facts, the really important parts of the case, to the judge in such a way that you've covered all of those seamlessly, but you have also explained why in your particular case, and all cases are different, with these facts, the judge should or should not do the thing that your client needs them to do. So to do that, you've really got to start out with an understanding of exactly what you want, an understanding of what the facts of the case are, and then you will use the law and the procedure that you've probably spent all day before learning, very likely just to make sure that it's being considered properly by the judge. And that, I think, is something that one gets better at with practice, but it's the thing that's really important for students who think, oh, law in civil and procedure in civil is very complicated. It can be, but the art is to make that simple and straightforward and really just instruct the judge into why they can do and should do the thing that your client needs them to do. And that's really most civil applications.
Okay, thank you for that. One thing that certainly I experience is students who make a point, i.e. they have a contention, but that contention is not supported, whether it be by statute, whether it be by case law, or perhaps just by evidence in the case itself. So, which necessarily leads to you saying, if someone makes a point, why? What is the best way for students to go about supporting their particular arguments? I mention this in particular because I think in academic law, i.e. university, when a lot of people are, which a lot of viewers at the moment will, that's where they'll be. Very often in academic law, you look at the case first. You extract from the case what you think the points are, and then you say, this is what that case means. I think in practical law, in the way we do it, it's the other way around, isn't it? This is what the case, this is the point I wish to make, and I'm going to take you to this case to support the proposition I've just made.
Yeah.
Is that right?
No, absolutely. And what we will be doing most of the time in the sort of advocacy that gets to court is you'll be asking the judge to exercise their discretion to do something they can do, but don't necessarily have to. So the real art there, and a lot of students were spending a lot of time telling the judge they can do this, and there are 8 different cases in which the court did, losing track really of the fact that they need to persuade the court. Very likely, yes, you can establish they can do it, why they should. And I think case law, yes, you'll do your research, and a lot of academic background stuff is about using case laws to establish a principle of what should happen. It doesn't really work that way often. They might establish what could happen. Sometimes it will establish what absolutely can't happen. But cases are so fact specific in most cases that you're never going to find a Court of Appeal decision exactly on all fours with the thing that you're arguing with the same principles. So you do have to be very good at analysing cases to see what the point that's being made really does say to the judge and how that can guide what you want them to be able to do in your case. So often you'll do a lot of legal research, which might satisfy you the court can do something, but throwing all of those cases in front of the judge are going to do you no good at all because they don't help the judge with your case and applying the rules to the situation that you're in. So that step back from academic work is a very important one, to being much more practical. You're having a conversation with a judge to try and get them to see your point and make some sort of order or judgment in your client's favour.
Thank you. And of course, submissions advocacy isn't just about oral advocacy, it's about written advocacy, because very often students will have to do a skeleton argument. So what would be involved in a skeleton argument? And what's the point, frankly, of a skeleton argument?
A skeleton argument, I mean, they have all sorts of purposes. The primary purpose of a skeleton argument is for you. So I always say to our students, every case you do, even if you don't have to do a skeleton argument, do one. All it really is is a note form. So it's called a skeleton for a reason. It sets out the submissions that you want to make in the order you want to make them in, with good, clear subheadings and sections. In doing that, you yourself will start thinking about, have I said this in the right place? It will have cross-references to the key bits of the evidence, so that when you're delivering your submissions, you know which bit of the witness statement it needs to go to. It's a very practical, sensible document. It should be short, because you need to be able to have it on the desk and see what's going to happen next. You'll hand it up to the judge, who should be able to, I always say the skim read test. Somebody should be able to skim read your skeleton and know what you're going to say, what your key arguments are, where the evidence is, and importantly, at the end, what you want the court to do. So it's such a practical document that one would do it anyway, and then you can give it to your opponent so they know what the arguments are going to be, what the live issues are, and give it to the judge and use it yourself throughout your submissions. So as long as you've got good submissions, you can have a good skeleton argument. I think as simple as that. And I know the thing that courts hate are lengthy skeleton arguments that go on for reams and reams, because they're useless, because nobody can actually read them in the allowable time.
For what you say, it fits in quite well with what Lady Justice Andrews said when she said essentially a skeleton argument should show, how would you explain to a friend who gets easily bored why you should win? I love that. Yeah. I thought that was fantastic.
Absolutely. And with good subheadings, not issue 1, issue 2, issue 3. Say, no, headlines. What am I saying now?
Sorry, Alex, I spoke over you. We have skeletons in crime, but obviously not to the same extent. And we were forever saying to students, the clue's in the title. It's a skeleton. You're talking about the bare bones of the argument and putting it as succinctly as you can. You add the flesh during your oral submission, but don't lose sight of it. If you've been asked for a skeleton, you're not being asked for chapter and verse. You are literally the bare bones of the submission.
And it's what you're going to say.
We've got a question here on skeletons. Would you mention the cases in the skeleton argument and then leave them out of the oral argument?
No. If you've got some case law that you've looked at and you're not going to mention it to the judge, don't put it in your skeleton. If you're going to mention a case, make sure it's worth it. If you go to court and you're relying on an authority and you put it in your skeleton, you will be expected to bring a copy of that case for your opponent or opponents, a copy for the judge. If you don't refer to it at all, they're going to want to know why you've given them all of these authorities. A lot of students, I think, will put lots of case law in their skeleton because they want to show that they've done lots of research. If it's not relevant, it absolutely does not belong in your skeleton. You might only want to, it might be important enough that you do want to mention a particular part of somebody's judgment, but you'd need to provide the actual document so that everyone can look and make sure you're not just paraphrasing, or there isn't perhaps a little bit more to it than that, which there often is. So it has to be important enough to justify that.
And it's very often, I'm sure all of us have experienced being in front of a judge who says, what's your best point? Somewhat gruffly often. That is advice, it seems to me, that's worth taking on board at the preparation stage. Actually, don't try and shoehorn in 20 points. If you've got 3 good points, jettison the rest, keep to the 3 and put your best point at the top. Is that fair enough?
Absolutely. Yeah, you need to think of all of these things. I mean, I talk about this a lot in drafting as well. And skeleton arguments, of course, are a form of drafting. Think of it in terms of there is negative marking. Don't throw everything in the hope that something will stick, and you definitely made sure you've got the right points in there somewhere. They'll be lost in the whole mix of it. You won't spend enough time on them, and the judge won't know that this is your best point. So often just reel backwards, think about, if you were the judge, what would be the most compelling thing here? Highlight that and get to it at an early stage. Now, structurally, it does need to make sense. If there's something you needed to mention before that to make sense of it, you'll do it in that order. But really do think about what the judge needs to know and what is going to be the most compelling thing. Because if you water it down with a law lecture, they'll probably be nodded off by the time you get to the really important bit that you wanted them to focus on. So absolutely, that's correct.
I'm going to move now to, I think, some general practical points, really about presentation in oral advocacy, certainly that we at the ICCA find that really are of general application to many students who are starting off. Before I do, there's one question from Barney here. I had a general question, says Barney, in terms of day-to-day classes in civil and crime, what materials do students use to learn? And are these provided by the ICCA, or do students need to acquire them themselves? So what are you in criminal? What do students use, Michelle?
So the entire course is on virtual learning on the VLE. So they have continual access to the online course and to be able to look at the materials and to plan appropriately. In terms of preparing for the day classes, which is what the question refers to, we give briefs. And so each week or each fortnight, a criminal brief is released to the students, and they will conduct a conference in that brief, first of all, and then move to cross-examination and examination in chief of the witnesses. So it's very much a case study, and the full brief is provided by the ICCA. In addition, of course, we give access as far as Blackstone's is concerned, and therefore any legal research. There's also access to Lexis and Westlaw to be able to conduct any investigations or any preparation that may be needed. So from the criminal advocacy perspective, the materials are completely provided by the ICCA. There'd be nothing additional that would be needed.
Thank you. But what about civil, Alex?
I've got it right in front of me. It never leaves my side. By the time you come to part 2, there's 2 volumes. This is the civil procedure rules. You are provided with that on the course. And part 1 of the course will involve some BSB assessments on that book. You'll keep it with you. That will be your friend for the whole of your career in civil. It is also online, so you don't need to lug the 2 books around. And that's within your resources. Yes, you'll need to do research. So on a wide variety of areas of law for the course. We have subscriptions to Westlaw and Lexis. Of course, at the ICCA, we also have the 4 best law libraries in the country for your perusal. So where things aren't available on Westlaw and Lexis, and there are still a few things, they're available in the INS library. And we have a legal research module on the course, and we will be giving you a lot more guidance in legal research because, of course, in practice, you won't have the whole of Westlaw and Lexis. So a lot of your time will be spent learning how to research from a variety of sources. But that's all with you. You won't need to buy a law library if that's really where your question was going, Ollie.
Thank you for that. Your fees contain everything you will need to do the course. There's no extras. And as Alex says, when you're on part 2, you can go to any of the INS libraries. And they are amazing places, as you'll all discover in due course. I want to move in the last 7 minutes. I can't believe it's gone this quickly. There's so much to talk about advocacy. That's why it's literally half of the part 2 course.
Yeah.
So there is a lot of, I was going to say excitement, and I mean it. There's so much to learn. Let's look at a few practical hints and tips and do's and don'ts. And I want to start with something that I know you've got a few views on, Michelle, which is about scripting. The idea that you come along to do your advocacy, whether civil or criminal, and essentially you have written out everything that you intend to ask or every submission you intend to make, and you have it on a script, and that's what you use. Is that a good approach, Michelle?
It's the exact opposite of what you should do. And it's certainly something that we hammer home from the start of the course. Scripting 100% does not work for a variety of reasons, Chris. First and foremost, the more detailed that your writing is, there is a tendency for your head to be down, therefore, and reading the document in front of you in whichever format that may be. Now, the issues with that, as far as criminal advocacy is concerned, is first and foremost, your voice will automatically be reduced in terms of volume and clarity because your head is now down. But importantly, you have to think about it in the sense of the witness handling. If it's your own client, for example, that you are taking through evidence in chief, they are looking to you to encourage them and to almost make sure that you are relying, you are pushing them to give their evidence. They want full engagement with you. And to that extent, you have to keep eye contact. And if you are down here reading somewhere, that's not happening. Just as important in cross-examination, there are times when we want the witness to feel uncomfortable. And the most important and obvious way to make someone feel uncomfortable is by staring at them. And if you're distracted by reading from a script somewhere, that's not going to happen. And that can make witnesses feel more in control, and that in effect, they're getting the better of you. The other important reason for not being scripted, Chris, is it's not advocacy. I could step out on the street now and grab hold of anyone and say, can you read this for me? It doesn't make someone a good advocate. And it also prevents people from adapting and being flexible. The problem is, if you are over prepared and you have your own script, you don't listen to answers that are being given because you are too busy focusing on what your next question is. And quite often, this is why we talked about criminal advocacy being so fast paced. A witness may say something that you weren't expecting, or they may give a different answer to the question than that you anticipated. And you have to make a very quick decision that, do I need to follow up? Do I need to, we call them piggyback questions, right? Do I need to ask some more questions to extract a bit more information around that? Conversely, if it's cross-examination and you're undermining the witness, you're very much listening for, that story has changed. This is completely different. And if you're scripted, I'm afraid, you tend not to listen to the answer because you're too busy focusing on the next piece of writing that you've got. So there are a whole variety of reasons there, Chris, why scripting does not work. And in fact, we can go as far as to say, and we do so during the induction week on the course, for criminal advocacy, students who are scripted, and we totally understand why people want this comfort blanket and want to show that they're prepared, and they'll be quite nervous in the first couple of weeks. But we give a very clear warning, I'm afraid. If they are scripted during their assessments, and part of the assessment criteria is communication and delivery. And in fact, the BSB have endorsed and approved that students cannot pass that subcategory if they are scripted. And so there is a very good incentive, you might think, from the start of the course, not only based on what your tutors are saying, but here we are, the BSB are saying to you, please don't do it because this is going to cost you significant marks in the assessments for the reasons we've just discussed. So scripting's a big no-no, Chris.
And do you experience the same in civil advocacy, Alex?
Well, absolutely. I was a little bit worried because I've just been talking about skeleton arguments that people might think, well, you have a script. One of the main reasons I say skeleton arguments should be skeletal, just really a headline and then a tiny smidgen of information about what you're going to say, is so you can't read it out. And a lot of people are tempted to write their full submissions down. There is such a thing as written submissions that get put before the court. This isn't what we're talking about. Your skeleton argument should be so skeletal that you could not read it out as a script for exactly the reasons Michelle was talking about. It would have a huge impact on your advocacy, which is about, you can look down, find the point, and talk to the judge. If you're not talking to the judge, you are not going to persuade them. No one wants to sit there and have someone just read something out without looking at them. And similarly, in most advocacy, it isn't going to be you just saying what you want to say. There will be a back and forth, and you're not going to be able to rely on any form of script at all. So the better you can get it, absolutely know what you want to say and know your information. But if you're scripted, yeah, you're sunk, I think.
I think also
how people give themselves away, Chris. We often get students and we know they're scripted and they'll say, I'm not. But people, if you're reading, think about it from a legal perspective. We tend to put legal words in, and there will be words such as hereto and furthermore. Or we have students who say, as aforesaid. And I'm thinking, no, that's not a natural way of just speaking to people. Yeah. So it's very easy for us to see not only the lack of eye contact, the clarity, but the actual words someone used will automatically come out if they're scripted. And then it's not natural in terms, obviously, of witness communication. So there are some dead giveaways which are easy for assessors to see.
No, that's really, really helpful. And I would say, I appreciate we're literally about to run out of time. To all budding advocates, also remember your pace. Don't try not to speak too quickly. It's almost worth writing on your notes, slow down. It's very, very useful to remind yourself. I'm afraid, brings us right to the end of this. I'd like to thank you all for attending. I'd like to thank Michelle and Alex for their insights, and I hope they've been really, really helpful to you all. And I very much look forward to, I hope, meeting all of you in due course. Please remember, if you don't know about this already, we have an open day on Saturday, the 9th of November, this year held at Middle Temple Hall, which will be a great day out. It's only half a day out. You can go to Covent Garden afterwards. Michelle can't be there this year, but I know Alex is going to be there.
I'll be there.
So, it'll be great to meet you, and you can ask any further questions you have. This webinar also has been recorded, so it will be on our events page. And from the events page, you can book the open day and you can see what else we're doing this year. Once again, it's been an absolute pleasure. Thank you so much for attending, and I wish you a wonderful week ahead. Take care.
Thanks, Chris.
Bye-bye.